Okay, now let's get to auxiliary aids and services, and because this is where we really start transitioning into websites, which of course is a huge issue in the ADA world lately. So we read the section of the ADA that requires providing auxiliary aids and services, and now we're looking at the regulations, and we see section 36.303, and the sub A here really just reiterates what we read in the actual law, that a public accommodation has to provide auxiliary aids and services unless it would fundamentally alter the nature of services provided or would be an undue burden. And then certain examples of auxiliary aids and services are provided. So, for example, qualified interpreters on site or through video remote interpreting services, note takers, real-time computer aided transcription services, written materials, exchange of written notes, telephone handset amplifiers, assistive listening devices, assistive listening systems, telephones compatible with hearing aids, closed caption decoders, open and closed captioning, including real-time captioning, voice text. This goes on and on, but the point is, these are all aids and services to make information available to those who it might not otherwise be perceivable by. Now, qualified readers, tape text, audio recordings, braille materials and displays, screen reader software, magnification software, optical readers, secondary audio programs, which SAP, large print materials, accessible electronic and information technology. Now, here's where we get to the part that's really relevant to websites, or other effective methods of making visually delivered materials available to individuals who are blind or have low vision. Okay? And this, as we'll see, is something that is largely relied upon, this language, for the argument that the ADA applies to websites. Okay? Next, acquisition or modification of equipment and devices, other similar services and actions. The regulations also advise that a public accommodation should consult with individuals with disabilities whenever possible to determine what type of auxiliary aid is needed to ensure effective communication, but the ultimate decision rests with the public. But the ultimate decision as to what measures to take rests with the public accommodation, provided that the method chosen results in effective communication. Here's an important issue. A public accommodation shall not require an individual with a disability to bring another individual to interpret for him or her. This is an issue that I've actually encountered in litigation, where you see it sometimes in like a doctor's office where somebody who's deaf will be asked to bring someone who can interpret for them. That's specifically disallowed. A public accommodation shall not rely on an adult accompanying an individual with a disability to interpret or facilitate communication, except, and then basically it's emergency situations where the person with the disability requests it, but the onus can't be put on the person with the disability to bring an interpreter with them, and that, of course, is an auxiliary aid or service providing interpretation for those who are deaf or have hearing impairments. Okay, now what is undue burden? Of course, if it's an undue burden, the auxiliary aid or service does not have to be provided. Undue burden means significant difficulty or expense. In determining whether an action would result in an undue burden, factors to be considered include the nature and cost of the action needed, the overall financial resources of the site involved in the action, the number of persons employed at the site, and this goes on. It's almost like readily achievable, right? You have to look at the finances and the wherewithal generally of the business that is being asked to provide the auxiliary aid and service. And generally speaking, businesses don't want to be in a position where they've been sued for not providing an auxiliary aid and now have to open up their books and records to prove that they couldn't afford it. If it's affordable, if it can be done, if it's within the wherewithal of the business to provide the auxiliary aid and service, that is something that the law requires. Okay, let's transition now into the topic of ADA website compliance, which has been a very hot topic in general in the ADA world, and I think in the business world, because many businesses are being sued for ADA violations on their website and are having to comply with the ADA. So now we're going to look for the first time at some case law. And this particular case that I've pulled up here is Robles versus Domino's Pizza, which is from the Ninth Circuit Court of Appeals, which is the appellate court under the U.S. Supreme Court, but which is where appeals go from various states, including California. The U.S. Supreme Court actually denied cert on this case, which means that they refused to hear it, which means for whatever reason the Supreme Court was not going to even hear an appeal of this decision. And what did this decision say? And we're going to look at some head notes. It would be too difficult to actually start reading deeply into the case law, but we're going to look at some of the notes that precede the case that sort of explain what it was all about. So the panel held that the ADA applied to Domino's website and app because the act mandates that places of public accommodation like Domino's provide auxiliary aids and services to make visually available materials available to individuals who are blind. And of course, we just read directly from the regulations ourselves where it says that. Even though customers primarily access the website and app away from Domino's physical restaurants, the panel stated that the ADA applies to the services of a public accommodation, not services in a public accommodation. Let's read that again. The panel stated that the ADA applies to the services of a public accommodation, not services in a place of public accommodation. The panel stated that the website and app connected customers to the goods and services of Domino's physical restaurants. So in this case, the Ninth Circuit Court of Appeal held that a website was subject to ADA requirements. Now, just a note here about the way that the federal judicial system is organized. Every place in the United States is within some district. So, Los Angeles is within the Central District of California. Miami is within the Southern District of Florida. Manhattan is within the Southern District of New York. Chicago is within the Northern District of Illinois. Buffalo, New York is within the Western District of New York. So every state is divided into these federal judicial districts, and then there are larger circuits, circuit courts of appeal, which apply to multiple districts. So again, for example, the 11th Circuit Court of Appeal covers Florida, Georgia, and Alabama. And then on top of these circuit courts is, of course, the U.S. Supreme Court. Now, unless the U.S. Supreme Court has ruled on something, there's not necessarily going to be uniformity across the country in terms of the rulings. Different district court judges may be ruling on things differently in different ways. Different circuit courts may be ruling on things in different ways. As I sit here today, there was a ruling recently from the 11th Circuit Court of Appeals, which really sort of rejected the idea that websites are covered by the ADA. But we do have this Ninth Circuit opinion saying that the websites are covered by the ADA. There isn't going to be uniformity until the Supreme Court rules, and there isn't going to be uniformity in terms of what absolutely needs to be done to create accessibility until the Justice Department issues guidelines saying what an accessible website is. But until those things happen, a prudent business with a public-facing website will make itself accessible, and we'll discuss what that means, what accessibility means right now, de facto, pending some type of actual regulation of this area. And that's in part because websites are viewable and usable all over the country. And yes, It's true that if a business with a website is sued somewhere where it's done no business or done very little business, it may be able to move to dismiss the lawsuit, saying that the court has no jurisdiction over it. But even if it is able to do something like that, it's already spent a tremendous amount of time, effort, money, stress, aggravation dealing with the litigation. And so even if litigation is winnable, you want to avoid it. That is what risk management is all about, is avoiding litigation in the first place. So because there are courts in the United States which do say that a website is subject to, a website of a place of public accommodation is subject to ADA regulations, and because websites are viewable throughout the United States, it's generally prudent to make a website ADA compliant. This isn't legal advice. If somebody feels that they're in a jurisdiction where that's not the rule and they don't want to do it, and they've spoken to their legal counsel and they feel that that's wise, then certainly that's their prerogative. But my opinion is that websites should comply, if for no other reason. Obviously they want to make themselves accessible, but if for no other reason than to avoid being sued. And I've represented many businesses in states where they have no connection at all, except that the plaintiff, who is visually impaired or blind, went onto the website in that state and couldn't view it. So, it's a question of how cautious one wants to be, but certainly there is legal authority for the proposition that websites apply to, or that the ADA applies to websites. And here are more head notes. The lack of specific regulations regarding website accessibility does not eliminate a defendant's obligation to comply with Title III of the ADA or excuse its failure to comply with the mandates of the ADA. So the lack of specific regulations regarding website accessibility, this goes back to what I was just saying, which is that unlike the ADAG, or the standards for accessible design, where we know what the Department of Justice says a ramp has to look like, and a parking lot has to look like, and an accessible bathroom has to look like, we don't know, there's no specific regulation on website accessibility. Having said that, de facto, there are some standards that are now being used widely, which we'll discuss in a moment. But what the court is saying here is that just because there are no specific regulations, that doesn't mean that the requirement to make the content of the website accessible to the visually impaired, which is written into the law itself, does not exist. I mean, it still exists, and according to this court, it means that websites have to be made ADA compliant. Another head note from this Robles case, which I'm quoting again extensively because it was sort of a big deal in the world of litigating website accessibility issues. Title III of the Americans with Disabilities Act expressly provides that that a place of public accommodation, like a restaurant, engages in unlawful discrimination if it fails to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services. DOJ regulations require that a public accommodation furnish appropriate auxiliary aids and services where necessary to ensure effective communication with individuals with disabilities. And DOJ defines auxiliary aids and services to include accessible electronic and information technology or other effective methods of making visually delivered materials available to individuals who are blind or have low vision. And of course, by now, anyone watching this class is familiar with those regulations because we read them directly. And so those are the regulations that that this opinion at least is largely based on. Now, how does one comply with the ADA on a website if there are no regulations that say exactly what website compliance, ADA compliance, looks like? And we're going to dive into this a bit, but let's just use another head note from this case since we're already here. Web accessibility guidelines, WCAG 2.0, are private industry standards for website accessibility developed by technology and accessibility experts. WCAG 2.0 guidelines have been widely accepted, including by federal agencies, which conform their publicly facing electronic content to WCAG 2.0 Level A and Level AA success criteria. In addition, the Department of Transportation requires airline websites to adopt these accessibility standards. Notably, the Department of Justice has required ADA-covered entities to comply with WCAG 2.0 Level AA in many consent decrees and settlement agreements in which the United States has been a party. Okay, so something that we haven't discussed so far is that the ADA is enforced by private lawsuits, but the DOJ may also bring a lawsuit against a violator. And I have been involved in assisting a business with a DOJ issue, not a private lawsuit. And so the DOJ settles these cases. And as the court here notes, in many of those settlements, the United States, the DOJ has required as a condition of the settlement that the ADA-covered entities comply with WCAG 2.0. So the point is we have a de facto standard here, taking authority from here and from there. WCAG standards, which do advance, they get more and more advanced, is the standard in order to make a website compliant with the ADA. So now that we know that the WCAG standards are the standards that the courts are saying, de facto at least, are the standard to be applied in these cases, what is the WCAG? And it's the Web Content Accessibility Guidelines. It's you can go to w3.org and look it up, and it will explain in more detail exactly what the WCAG guidelines are. I'm not a tech person. I'm not a computer guy. I don't know anything about coding, but there are a lot of people out there who know a lot about it. There are a ton of consultants. Frankly, any good computer website developer company should know a lot about this and know how to make a site compliant. A lot of people, including me, have their websites on other platforms and are relying on those platforms to make sure that they are ADA compliant. But anybody who wants to can go and look up what ADA compliance is directly on this website, and I will provide a link to it.